Hello, everyone. Thank you for joining Group 3. My name is Hannah May S. Atienza, and with me are my groupmates, Mr. Alan Francis Benjamin G. Calub, Ms. Precious Iric R. Inosa, and Mr. Don Renz M. San Jose. We are here to discuss cases assigned to us, and we are very pleased to have the opportunity to share with you our presentation. Throughout this discussion, we will delve into cases under the Judicial Department, the Constitutional Commission, and accountability of public officers. Our hope is that this presentation will not only serve as a helpful review for the bar exams, but will also deepen our knowledge and understanding of the law. So without further delay, let us begin. First case is Pimentel et al. Versus Legal Education Board. RA 7662, also known as a Legal Education Reform Act of 1993, was passed to improve the system of legal education due to poor performance in the bar examinations. The act created the Legal Education Board as an executive agency separate from the Department of Education. Amendments were proposed by the Courts Committee on Legal Education and Bar Matters and were approved by the Supreme Court in 2001. The Legal Education Board became fully operational only on June 2010. The Legal Education Board has issued a memorandum to improve the quality of legal education by requiring all those seeking admission to the basic law course to take and pass the PhilSat. It is a nationwide uniform law school admission test. The PhilSat is an aptitude test measuring skills such as communication and language proficiency, critical thinking, and verbal and quantitative reasoning. So the petitioners in this case filed a petition for prohibition to declare RA number 7662 and the creation of the Legal Education Board unconstitutional, including PhilSat, which they claim encroaches upon the rulemaking power of the court regarding admissions to the practice of law. The petitioners in this case include lawyers, taxpayers, law professors, current law students, and citizens who intend to study law. They prayed for a temporary restraining order to prevent Legal Education Board from conducting the PhilSat. Petitioners argued that RA number 7662 and the PhilSat are offensive to the court's power to regulate and supervise the legal profession, and that Congress cannot create an administrative office that exercises the court's power over the practice of law. They also challenged the constitutionality of certain powers of the Legal Education Board. On the other hand, respondents argued that RA 7662 enjoys the presumption of constitutionality and that the study of law is different from the practice of law. They further argued that the right of citizens to accessible education means that the state shall make quality education accessible only to those qualified enough, as determined by fair, reasonable, and equitable admission and academic requirements. So there are two issues that I would like to discuss in this case. First is the procedural issue, which is whether or not remedies of certiorari and prohibition are proper in this case. And the second issue is a substantive issue on whether or not the court has jurisdiction over legal education. First, as to the procedural issue, the court ruled in the affirmative. The correct remedies of certiorari and prohibition were used to invoke the court's expanded jurisdiction. These remedies are appropriate for raising constitutional issues even if they challenge a legislative act. The Constitution grants the court the power of judicial review, explicitly stated in Section 5, Article 8 of the Constitution. The court's expanded jurisdiction allows the review of acts by any branch or instrumentality of the government, including the legislative and executive branches, without any other remedy in the ordinary course of law. As to the substantive issue, the argument assumes that the court has the power to regulate legal education as a necessary result of its power to regulate admission to the practice of law. But this assumption lacks legal support. Doing so would exceed its constitutional mandate, violate the doctrine of separation of powers, and be an act of judicial activism. The regulation and supervision of legal education are primarily exercised by the legislative and implemented by the executive, not the judiciary. Let's now move on to the second case. Film Development Council of the Philippines versus Colon Heritage Realty Corporation. In 2002, the Film Development Council of the Philippines, or FDCP, was created by Congress with the passing of Republic Act No. 9167. Sections 13 and 14 of the Act dictate that the amusement tax accrued from certain graded films exhibited in Metro Manila and highly urbanized and independent component cities in the Philippines should be deducted and remitted to the FDCP by theater proprietors, operators, or lessees. The FDCP will then reward the same to the producers of the graded films. Sections 13 and 14 of RA 9167 were declared unconstitutional for violating local fiscal autonomy and allowing FDCP to confiscate amusement taxes, which rightfully belongs to the LGUs. The doctrine of operative fact was applied, meaning legal effects produced by the provisions before being declared unconstitutional, it need not to be undone. FDCP's motion for reconsideration was denied, making the decision final and executory. In this case, SMPHI has brought to the court's attention the FDCP's chairperson and CEO, which directed theater owners to process all amusement tax remittances accorded to the film graded before December 10, 2019, with a warning of legal action for non-compliance. So here, the SMPHI is seeking for the court's clarification on its decision. So the issue in this case is whether or not SMPHI should remit to FDCP amusement taxes withheld or which were due for remittance after December 10, 2019, specifically for the graded films exhibited during the Metro Manila Film Festival. The court ruled in the negative. The amounts paid by Colon Heritage to FDCP need not to be returned, and the doctrine of operative fact applies in this case. I will just highlight what is important to note in this case when it comes to the Judicial Department. Since SMPHI seeks clarification to the court, it was stated in the decision that it is apt to note that that the propriety to clarify the court's own decision or resolution in a given case rests on its sole prerogative, in line with its inherent power to amend and control its process and order so as to make them conformable to law and justice. As held in one case, quote unquote, the inherent power of the court carries with it the right to determine every question of fact and law which may be involved in execution. Let's now move on to the next case. Mandanas versus Ochoa. The 1987 Constitution emphasizes the decentralization of government and local autonomy. Local autonomy has two aspects, administrative and fiscal. Fiscal autonomy means that local governments have the power to create their own source of revenue and allocate resources in line with their priorities, in addition to their equitable share in national taxes. Pursuant to this constitutional dictum, Congress enacted Republic Act No. 7160, otherwise known as the Local Government Code. The share of the local government units, known as the Internal Revenue Allotment, is regularly released based on the actual collections of the National Internal Revenue Taxes certified by the BLR, as per the implementing rules and regulations of the Local Government Code. So in this case, Mandanas et al. Is a special civil action for certiorari, prohibition, and mandamos, assailing the manner the General Appropriations Act for fiscal year 2012 has been computed, the IRI for the LGUs. So the issue in this case is whether or not mandamos is the proper vehicle to assail the constitutionality of the relevant provisions of the General Appropriations Act and the Local Government Code. The court ruled in the negative. Mandanas et al. Seek the writ of certiorari, prohibition, and mandamos, while Garcia prays for the writ of mandamos. Both groups of petitioners impugn the validity of Section 284 of the Local Government Code. For the writ of mandamos to issue, the petitioner must show that the act sought to be performed or compelled is ministerial on the part of the respondent. Considering that its determination of what constitutes the just share of the local government units in the national taxes under the 1987 Constitution is an entirely discretionary power, Congress cannot be compelled by writ of mandamos to act either way. The discretion of Congress thereon, being exclusive, is not subject to external direction. Otherwise, the delicate balance underlying our system of government may be unduly disturbed. The petition, well dubbed as a petition for mandamos, is also a petition for certiorari because it alleges that the Congress thereby committed grave abuse of discretion amounting to lack or excess of jurisdiction. It is worth reminding that the actual nature of every action is determined by the allegations in the body of the pleading or the complaint itself, not by the nomenclature used to designate the same. So in a jurisprudence, specifically in Arroyo versus Aquino III, the court has emphatically opined that the court's certiorari jurisdiction under the expanded judicial power as stated in the second paragraph of Section 1, Article 8 of the Constitution can be asserted as follows. To set right and undo any act of grave abuse of discretion amounting to lack or excess of jurisdiction by any branch or instrumentality of the government, the court is not at all precluded from making the inquiry provided the challenge was properly brought by interested party or affected parties. The court has been thereby entrusted expressly or by necessary implication with both the duty and obligation of determining in appropriate cases the validity of any assailed legislative or executive action. This entrustment is consistent with the Republican system of checks and balances. Let's now move on to the next case. Francisco I. Chavez versus Judicial and Bar Council, Senator Francis Escudero and Representative Neil C. Tupas. The executive and legislative branches have always had the exclusive right to appoint members of the judiciary, as evidenced by historical records predating the current constitution. Similar to its American predecessor, both the Malolos Constitution and the 1935 Constitution granted the President the power to appoint judiciary members, subject to the confirmation of the Commission on Appointments. Unfortunately, these led to the unsavory practice of judicial aspirants seeking confirmation by currying favor with legislative members. Following the 1973 Constitution, which fused executive and legislative powers, the appointment of judges and justices became absolute, with the exception that the appointees must meet all qualifications and none of the disqualifications. In response to the clamor of the public against political interference and partisan activities in the appointment process, the Constitutional Commission created the Judicial Bar Council, or JBC, to recommend nominees to the President. The JBC, composed of nominees to the President, the JBC, composed of stakeholders in the appointment process, has a specified term and functions outlined in Section 8, Article 8 of the Constitution. In 1994, the composition of the JBC was substantially altered. Instead of only having 7 members, an 8th member was added to the JBC, as 2 representatives from Congress began sitting in the JBC, 1 from the House of Representatives and 1 from the Senate, with each having 1/2 of a vote. Then, JBC and BAC, in separate meetings held in 2000 and 2001, decided to allow representatives from Senate and the House of Representatives 1 full vote each. At present, during the pendency of the case, Senator Francis Joseph Escudero and Congressman Neil C. Tupas Jr. simultaneously sit in the JBC as representatives of the legislature. The petitioner in this case questioned this through his petition. He argued that the framers of the Constitution clearly envisioned and contemplated and decided on a JBC composed of only 7 members. Through the Office of the Solicitor General, the respondents defended their position as members of the JBC in their comment by citing Section 1, Article 6 of the Constitution to determine the meaning of the term quote-unquote Congress. They argued that both the Senate and the House of Representatives are mandatory components of the Congress and that the absence of either divests the term of its substantive meaning as expressed under the Constitution. Therefore, when Section 8, Article 8 of the Constitution speaks of quote-unquote a representative from Congress, it should mean 1 representative each from both houses, which comprise the entire Congress. Tracing the subject provision's history, the respondents claimed that when the JBC was established, the framers originally envisioned a unicameral legislative body, thereby allocating a representative of the National Assembly to the JBC. The phrase, however, was not modified to aptly jive with the change to bicameralism. The legislative system finally adopted the Constitutional Commission on July 21, 1986. They argued that if the Constitutional Commissioners were aware of this change, they would have made the necessary adjustments in the representation of the Congress in the JBC. The respondents further argued that adherence to the disputed provisions language would create absurdity and incongruity with the bicameral nature of Congress. Placing either respondent in the JBC would deprive the House of Congress of its representation and the electorate of their only opportunity to participate in the judiciary's nomination process, effectively diminishing the Republican nature of the government. So the issue in this case is whether or not the current practice of JBC to perform its functions with 8 members, 2 of whom are members of the Congress, runs counter to the letter and spirit of the 1987 Constitution. The court ruled in the affirmative. From a simple reading of the provision, it can be readily discerned that the provision is clear and unambiguous. The use of the singular letter A preceding representative of Congress is unequivocal and leaves no room for any other construction. It is indicative of what the members of the Constitutional Commission had in mind, that is, Congress may designate only 1 representative to the JBC. Had it been the intention that more than 1 representative from the legislature would sit in JBC, the framers could have, in no uncertain terms, so provided. It is Worthy to note also that the 7-number composition of the JBC serves a practical purpose, that is to provide a solution should there be a stalemate in voting. So, doubtless, the framers of our Constitution intended to create JBC as an innovative solution in response to the public clamor in favoring eliminating politics in the appointment of members of the judiciary. This is to ensure judicial independence. They adopted a holistic approach and hoped that in creating a JBC, the private sector and the three branches of the government would have an active role and equal voice in the selection of the members of the judiciary. Therefore, to allow the legislative to have more quantitative influence in the JBC by having more than one voice speak, whether with one full vote or one half vote each, would, as one former congressman and member of the JBC put, quote unquote, negate the principle of equality among the three branches of the government, which is enshrined in the Constitution. That ends my part of discussion. Thank you for your kind attention. I will now give the floor to Mr. Calub. Thank you.
Thank you for that presentation, Ms. Atienza. Good afternoon, everyone. I am Alan Francis Benjamin G. Calub, and I will be discussing my first case, Pedro S. Agkawili et al. Versus the Honorable Farinas et al. Now, before we continue, a brief overview of what we expect in this presentation. Of course, the facts, the issue, the ruling, and the discussion. If there may be any other additional discussions that I may discuss during the presentation. Okay, first for the facts. House Resolution number 882 was introduced by respondents directing the House Committee to conduct an inquiry in aid of legislation pertaining to the use by the provincial government of Ilocos Norte of its shares from the excise taxes on locally manufactured Virginia-type cigarettes for purposes other than what is provided in RA number 7171. For additional information not included in this presentation, what was in question to the petitioners were government vehicles that were allegedly misappropriated and were used by the provincial government of Ilocos Norte. During the legislative hearings, respondents were held in contempt for failing to answer the questions of the House Committee despite being questioned several times. These were inquiries on the disbursements and accounts of cash that were coming out of the provincial government of Ilocos that they refused to answer. Hence, they were held in contempt. The petitioners alleged at the time when they were held in contempt and detained that they were subjected to threats and intimidation. As a result, after being detained due to contempt, the petitioners filed for a petition for habeas corpus against the respondent Sergeant at Arms Lieutenant General Detbali. Additionally, during the hearing of the habeas corpus, Lieutenant General Detbali was called several times, but he was not able to appear so in court because during the hearing, he was accompanying another trip by the House Committee. CA ordered Detbali the delivery of the body subject to the habeas corpus but failed to do so. A motion for provisional release to the Court of Appeals was filed by the petitioners and was granted by the Court of Appeals. They were immediately released, and subsequently, several hearings were also held by the House Committee against the Court of Appeals on why such provisional release was granted. While the petition for habeas corpus was still pending before the Court of Appeals, the House Committee lifted the contempt order and ordered the release of the petitioners and were released on the same date. The Court of Appeals issued a resolution in the pending habeas corpus considering the case closed and terminated for the grounds of mootness. Now, for the issues. For the first issue, it is whether or not the writ of habeas corpus may be considered moot based on the subsequent release of the petitioners. And for the second issue, whether or not the Supreme Court can assume jurisdiction over the habeas corpus by invoking the power of administrative supervision of the Supreme Court over the Court of Appeals. Now we will discuss the ruling on the first issue. The Supreme Court ruled that yes, the petition for habeas corpus is already moot. On the case itself, the Supreme Court held subtitles which summarily discussed the cases. For the first issue, they stated that the release of persons in whose behalf the application for a writ of habeas corpus was filed renders the petition for the issuance thereof moot and academic. As provided in the Rules of Court under Section 1, Rule 102 thereof, a writ of habeas corpus shall extend to all cases of illegal confinement and detention by which any person is deprived of his liberty, or by which the rightful custody of any person is withheld from the person entitled thereto, concerning the pleading, practice, and procedure in all courts and its authority to exercise jurisdiction in all courts. Far compelling than the question of mootness is the element of illegal deprivation of freedom of movement or illegal restraint in is jurisdictional in petitions for habeas corpus. Consequently, in the absence of confinement and custody, the court's lack of power to act on the petition of habeas corpus and the issuance of a writ thereof must be refused. In this case, the Supreme Court no longer considers that there be a need to continue the petition for the writ of habeas corpus, mainly because on the grounds that there was no longer confinement against the petitioners. They were released. The contempt order against them was released. Continue. Any lingering doubt as to the justiciability of the petition to assume jurisdiction over the habeas corpus petition before the Court of Appeals is ultimately precluded by the CA resolution considering the petition closed and terminated. With the termination of the habeas corpus petition before the CA, petitioners plea that the same be transferred to this court or that the court assume jurisdiction thereof must be necessarily denied. In relation, before we go to the second issue, after in relation before we go to the second issue, the Supreme Court, uh, before we relate to the second issue, I'm sorry, the petitioners to wanted the Supreme Court to take over the case, to take over the habeas corpus case from the CA, which we go to the in which we go to the second issue. No, administrative supervision merely involves overseeing the operations of agencies to ensure efficient management. Now, as the subtitles in the case states, the court's administrative supervision over lower courts does not equate to the power to usurp jurisdiction already acquired by lower courts. The Supreme Court states that the Constitution vests upon the Supreme Court the original jurisdiction over petitions for habeas corpus, while lower courts were given the jurisdiction by BP 129 as amended. The Supreme Court, as well as the Court of Appeals, the Regional Trial Court, and other concurrent and lower courts with a concurrent jurisdiction to hear and try petitions for habeas corpus. This conferment of jurisdiction finds procedural translation in Rule 102, Section 2, which provides that an application for a writ of habeas corpus may be made before this court or any member thereof, or the Court of Appeals or any member thereof, and if so granted, the same shall be enforceable anywhere in the Philippines. This means that all courts may have original jurisdiction, and you can file to them originally a writ of habeas corpus. Now, with the issue regarding the administrative supervision, the Supreme Court clarifies that administrative supervision, which shall govern the administrative relationship between a department or its equivalent and regulatory agencies as may be provided by law, shall be limited to the authority of the department to generally oversee operations and to ensure efficient management, but without interference with day-to-day activities. This means that the Supreme Court has no power to actually take over the case of the Court of Appeals, knowing that they already acquired jurisdiction thereof. They explained that administrative supervision is only to oversee, to have an efficient management system of the agency itself. To continue, thus, to effectively exercise its power of administrative supervision over all courts as prescribed by the Constitution, Presidential Decree number 828 as amended created the office of the court administrator. Nowhere in the functions of the several offices in the office of the court administrator is it provided that the court can assume jurisdiction of a case already pending with another court. Petitioners are without unbridled freedom to choose which between this court and the Court of Appeals should decide the habeas corpus petition. Mere concurrency of jurisdiction does not afford the parties absolute freedom to choose the court to which the petition shall be filed. After all, the hierarchy of courts also serves as a general determinant of the appropriate forum for petitions for extraordinary writs. Now, Rule 4, Section 3C of AM 10-4-20-SC provides that the transfer of cases from one court administrative area or judicial region to another of the transfer of venue or trial of cases to avoid miscarriage of justice. The above-mentioned provision only relates to the power of the Supreme Court to transfer cases as a matter of venue rather than jurisdiction to avoid miscarriage of justice. Thank you. That is my presentation for this case. Now we will discuss the second case. It is regarding the complaint affidavit of Enables et al. Against former Chief Justice De Castro. Again, an overview, the facts, issue, and ruling of this case. Facts. Elvira N. Enables, Rebecca H. Angeles, and Estelita B. Ocampo filed an administrative case against former Chief Justice Teresita J. Leonardo de Castro, charging her with gross ignorance of the law, gross misconduct, gross dishonesty, and conduct prejudicial to the best interests of the service in connection with the petition of spouses Malaris, petition for mandamus and prohibition, with prayer for temporary restraining order, which was raffled to Chief Justice De Castro. The case itself does not give details into what were those cases filed by spouses Malari. To continue, despite the lapse of more than 5 years, Chief Justice De Castro failed to decide on both petitions of spouses Malari. The complainants aver that, number one, respondents' failure to comply and promptly act on the petitions resulted in a violation of the spouse's constitutional right to a speedy disposition of their cases. Number two, this is the second averment is not really discussed in the case, but they stated that the complainants further argued that the respondent committed graft and corruption for giving the Philippine National Bank unwarranted benefits through manifest partiality, evident bad faith, or gross inexcusable negligence causing undue injury to the Malari spouses. The complainants rely, based on their complaint affidavit, on the constitutional provision requiring that the court to decide cases within 24 months from their submission. Now, the provision in question is actually Section 15 of Section 15, Article 8 of the 1987 Constitution. Section 15 states that for the first paragraph, all cases or matters filed after the effectivity of this Constitution must be decided or resolved within 24 months from date of submission for the Supreme Court, and unless reduced by the Supreme Court, 12 months for all lower collegiate courts and 3 months for all lower courts. A case matter shall be deemed submitted for decision or resolution upon the filing of the last pleading, brief, or memorandum required by the rules of court or by the court itself. Issue: whether or not the 24-month period as mentioned in the Constitution of the court to decide cases is a mandatory provision. Ruling, the Supreme Court actually stated that no, the 24-month period is merely directory. It is not a mandatory period that where a case is submitted for final decision, the Supreme Court is required to answer accurately within 24 months or to file a decision within 24 months. The ruling. The Supreme Court cited a precedent. This precedent is Marcelino versus Cruz. To discuss, Marcelino involved a petition for prohibition and writ of habeas corpus filed against respondent Judge Fernando Cruz Jr., praying that he be enjoined from promulgating a decision in a criminal case entitled People of the Philippines versus Bernardo Marcelino. Petitioner Marcelino argued that the respondent Judge Cruz lost his jurisdiction on the case when he failed to render a decision within 90 days from the case's submission for resolution. The court then, upon receiving the case, found that the respondent did not render a decision within 3-month period prescribed under the 1973 Constitution. Now, they cited another case in that Marcelino versus Cruz case. The Supreme Court stated that statutes requiring the rendition of judgment forthwith or immediately after the trial or verdict have been held by some courts to be merely directory, so that non-compliance with them does not invalidate the judgment, on the theory that if the statute had intended such result, it would clearly have indicated it. The constitutional provision is merely directory in nature. Constitutional provisions are to be construed as mandatory unless, by express provision or by necessary implication, a different intention is manifest. Now, the Supreme Court further ruled that being the court of last resort, this court should be given an ample amount of time to deliberate on cases pending before it. Ineluctably, leeway must be given to magistrates, or in this case, justices, for them to thoroughly review and reflect on the cases assigned to them. This court notes that all matters brought before it involves rights which are legally demandable and enforceable. It would be at the height of injustice if the cases were hastily decided on the risk of erroneously dispensing justice. So in this case, the Supreme Court ruled that that the 1987 Constitution provision, a 24-month period, is only again directory. It being directory, it only serves as the guidelines for the justices to have a cap or a maximum ceiling period until when they should decide their cases. While the 24-month period under the 1987 Constitution is persuasive, it does not summarily bind this court to the disposition of cases brought before it. It is a mere directive to ensure this court's prompt resolution of cases, and should not be interpreted as an inflexible rule. Magistrates must be given discretion to defer the disposition of certain cases to make way for other equally important matters in this court's agenda. Now, as precedent, the Supreme Court added Cosculuela versus Sandigan Bayan, in which they stated that the right to speedy disposition of cases should be understood to be a relative or flexible concept, such that a mere mathematical reckoning of the time would not involve reckoning of the time involved would not be sufficient. This prescribed time limit not be ignored as to render nugatory the spirit which breathes life to the letter of the 1987 Constitution. Ultimately, courts must strike an objective and reasonable balance in disposing cases promptly while maintaining judicious tenacity in interpreting and applying the law. Accordingly, respondents' failure to promptly resolve the Malari spouse's petition does not constitute gross ignorance of the law warranting administrative liability. Thank you. That is my presentation for the second case. Okay, everyone, classmates, I will now discuss the third case. It is Sixto S. Brillantes versus Heidi B. Yorak. Again, an overview of what to expect, the facts of the case, the main issue, and the ruling. A brief introduction of this case. Here comes a question: is in case of vacancy in the Commission of Elections of the chairman position, is the president allowed to issue to designate a temporary acting chairman? Now for the facts. Here are the three parties that were. Here are the three. Here are the three important figures in this case: President Aquino, Chairman Heidi Yorak, and Chairman Hilario David. Facts. Heidi Yorak was designated by President Aquino as an acting chairman of the Commission on Elections, in lieu of Chairman Hilario David. Petitioner, Brillantes, seeks to challenge this designation in alleging that the same is unconstitutional. The petition was filed on the grounds that the President has no power to make such designation since COMELEC is an independent constitutional body, as provided in Article 9C, Section 1, Paragraph 2 of the 1987 Constitution. To wit, in no case shall any member be appointed or designated in a temporary or acting capacity. Petitioner contends that the choice of the acting chairman of the COMELEC is an internal matter that should be resolved by the members themselves, and that the intrusion of the President of the Philippines violates their independence. In his comment, the Solicitor General argues that no such designation is necessary in the case of the Supreme Court because a temporary succession is provided for in Section 12 of the Judiciary Act 1948 and Section 5 of BP 129. The designation made by the President of the Philippines should therefore be sustained for reasons of administrative expediency to prevent the disruption of the functions of the COMELEC. In this case, the Solicitor General made a comparison of how should a temporary designation be made between the Supreme Court and other courts and the constitutional commissions. However, that cannot blend because the constitutional commissions are a separated independent function from the judiciary. Issues: whether or not the designation by the President of the Philippines of Respondent Heidi Yorak as acting chairman of the COMELEC is it unconstitutional? The ruling, the short answer, yes it is. The designation by the President of the Philippines of Yoras as acting chairman of the COMELEC is unconstitutional, stating Article 9, Section 1 of the 1987 Constitution describes all the constitutional commissions as independent. Although essentially executive in nature, they are not under the control of the President of the Philippines in the discharge of their respective functions. Each of these commissions conducts its own proceedings under the applicable laws and its own rules in the exercise of its own discretion. A designation as acting chairman is by its very terms essentially temporary and therefore revocable at will. No cause need be established to justify its revocation. Assuming its validity, the designation of the respondent as acting chairman of the Commission on Elections may be withdrawn by the President of the Philippines at any time for whatever reason she sees fit. It is doubtful if the respondent waiving accepted such designation will not be stopped from challenging its withdrawal. Thank you. Okay, everyone, now I will be discussing the case of FUNA versus Commission Appointment Chairman Reynaldo Villar. Again, before we continue, an overview, the facts, issue, ruling, and discussions which may come along the way as we discuss this case. Before I continue, please observe the timeline presented. Before we continue, please observe the timeline presented, and it is a summary of what ensued before the case was even tried. Okay, petitioner challenges the constitutionality of the appointment of the respondent, and the facts are as follows. President Gloria Macapagal Arroyo appointed Guillermo N. Carage in February 2, 2008 as the chairman of the Commission on Audit to serve for a term of 7 years. In February 7, 2004, Commissioner Villar was appointed by President GMA as a commissioner for the Commission on Audit for a term of 7 years. Upon the retirement of Carage in 2008, Villar was designated as the acting chairman, and the formal appointment coupled with the approval of the commission appointments that Mr. Villar is promoted to be the chairman of the Commission on Audit. He became an interim chairman and was then appointed for a bona fide appointment. However, Villar challenged the appointment given to him by President GMA, insisting that his appointment as COA chairman accorded him a fresh term of 7 years, which is yet to lapse. He argued that his term of office as chairman is up to February 2, 2015, or 7 years reckoned from February 2, 2008, when he was appointed to that position of chairman. However, before the court could resolve the issue, Mr. Villar sent a letter to the then subsequent President Benigno S. Aquino, that he will step down, rendering this case moot. Now, the issues at hand. There are two issues mainly on this case. First is the relevant and substantial issue. Whether or not Villar's appointment as Commission on Audit Chairman, while sitting in that body and after having served for 4 years of his 7-year term as COA Commissioner, is valid in light of the term limitations imposed under the circumscribing concept tucked in Section 1, Paragraph 2, Article 9D of the Constitution. And next, we will go to the other issue, which is only the procedural issue, whether or not requisites of judicial review have been met. We stated the procedural issue because, as stated earlier, the petition challenges the constitutionality of the appointment of the respondent. The constitutionality was challenged, so therefore the court must determine judicial review. Short answer: ruling on the relevant and substantial issue. No. The appointment of Villar is not constitutional. The court, citing the Constitution, provides Section 1, Paragraph 2 provides that Article 9D, the Constitution provides that the chairman and the commissioners on audit shall be appointed by the President with the consent of the Commission on appointments for a term of 7 years without reappointment. Of those first appointed, the chairman shall hold office for 7 years, one commissioner for 5 years, and the other commissioner for 3 years without reappointment. Appointment to any vacancy shall only be for the unexpired portion of the term of the predecessor. In no case shall any member be appointed or designated in a temporary or acting capacity. Temporary or acting capacity, this was in relation to the previous case discussed. Petitioner now asseverates that the view that Section 1, Paragraph 2, Article 9D of the 1987 Constitution prescribes reappointment of any kind within the Commission. The point being that a second appointment, be it for some position or upgraded position, is a prohibited reappointment and is a nullity ab initio. So what the petitioner was also asserting is that the appointment of Villar be considered unconstitutional, mainly on the grounds that he was already appointed before. Another issue, if he is appointed to be a chairman from his position as a commissioner, which he has already served for 4 years, that issues another appointment paper, which the petitioner's opinion is that it is already considered a reappointment. Now, the Supreme Court discussed thoroughly the provision relevant in this case, which we'll go to next. The Supreme Court did not agree. The Supreme Court declares the appointment of Villar as chairman to be unconstitutional. Why? We will discuss this in the next slide. The rotational system. To give a brief background, the 1987 Constitution states that the chairman and the commissioner shall be appointed by the President with the consent of the Commission Audit for a term of 7 years without reappointment. Note that the provision also states that of those first appointed, the chairman shall hold office of 7 years, one commissioner for 5 years, and the other commissioner for 3 years without reappointment. The rule on the 7 years, 5 years, and 3 years is no longer applicable today because because the Supreme Court states that what the Constitution actually provides in this case, provides in this provision, are those first appointed once the 1987 Constitution was ratified. So in this case, all the subsequent appointments of the next chairman and the next two commissioners shall now have a maximum period of 7 years. Now we go to the question of why is it called a rotational system. The purpose of this the rotational system is that each chairman, each of the two commissioners shall not all be appointed at the same time, and instead shall be appointed with the interval of 2 years each. This purpose is so that because the constitutional commissions are independent from the other departments of government, it is a safeguard that the next president or who did not appoint them will not have full control over the chairperson and the commission. Now, to continue, the appointment of members or any of the three constitutional commissions after the expiration of the uneven terms of office of the first set of commissioners, as I discussed earlier, shall always be for a fixed term of 7 years. An appointment for a lesser period is void and unconstitutional. The appointing authority cannot validly shorten the full term of 7 years in case of the expiration of the term, as this will result in the distortion of the rotational system prescribed by the Constitution. Again, the 3, the 5, and the 7 no longer apply in this case. Each appointment of the chairperson and the two commissioners have an interval of 2 years. Now, we now discuss the unexpired portion. Appointments to vacancies resulting from certain causes like death, resignation, disability, or impeachment shall only be for the unexpired portion of the term of the predecessor. But such appointments cannot be less than the unexpired portion as will likewise disrupt the staggering of terms laid down under Section 1, Paragraph 2, Article 9b. To discuss further, this means that to discuss further, this means that for the unexpired portion provision on the 1987 Constitution to apply, this means that if a commissioner chairman is to resign before the full 7-year term, if he was to be replaced, he will only his replacement will only cover the unexpired term. For example, Commissioner A was appointed during uh, for the purposes of discussion. Let's say in the year 2000, Commissioner A was appointed by the then president. Then for some reason, Commissioner A on his fifth year was has either died, resigned, became disabled, or was impeached by the people. Then the next commissioner who will replace him will only be allowed to have a term of 2 years until he is again replaced. Because why only 2 years? Because if if the next commissioner will start with a fresh period of 7 years, then that will violate the constitution because each member of the commission is only allowed for a maximum period of 7 years. In this case, because Commissioner A had already consumed 5 years of his term, there is still a remaining 2 years left in his term. So as the court validly stated, as the court validly stated, so as the court validly stated, a term lower or more than that cannot apply to the next commissioner which will replace Commissioner A because it would disrupt the rotational system. For cases of reappointment, members of the commission who were appointed for a full term of 7 years and who served the entire period are barred from reappointment to any position in the commission. Corollary, the first appointees in the commission under the Constitution are also covered by the prohibition against reappointment. A commissioner who resigns after serving in the commission for less than 7 years is eligible for an appointment to the position of chairman for the unexpired portion of the term of the departing chairman. Such appointment is not covered by the ban on reappointment, provided that the aggregate period of length of service as commissioner and the unexpired period of the term of the predecessor will not exceed 7 years, and provided further that the vacancy in the position of chairman resulted from death, resignation, disability, or removal by impeachment. To discuss further on the topic of reappointment, we must note that it is absolute that reappointment is not allowed in this case. What the Supreme Court stated is not a reappointment, but a continuance of the service of a commissioner who was then appointed to the position of a chairman. The court clarifies that reappointment found in Section 1 to 1 paragraph 2 Article 9 means a movement to one end, the same office. On the other hand, an appointment involving a movement to a different position or office would constitute a new appointment and hence not in the strict legal sense. Any member of the commission cannot be appointed or designated in a temporary or acting capacity. Now, for the issue of temporary acting capacity, it was already previously discussed in the previous case that uh, that that vacancies in the position in the vacancies in the position in the constitutional commissions is an internal act in which the president cannot designate or appoint acting members to the position. Now, the discussion in relation to Villar. Nothing in the Constitution prohibits promotional appointment of Villar from commissioner having to serve the term of 4 years to chairman, provided that it is made under the aforestated circumstances or conditions. These conditions are: number 1, that if a commissioner was to be appointed as chairman, he shall not, the predecessor chairman shall not have expired the entire 7 years. Instead, he should have died, resigned, became disabled before the expiration of the 7 years. In this case, the succeeding commissioner may be appointed, but may be appointed as chairman, but he shall only be a chairman for the term of his unexpired portion. There can be no fresh period of another 7 years once he is appointed as chairman, mainly because it will destroy or ruin the rotational system that is prescribed by the Constitution. It would be unconstitutional. Like in the case of Villar, however, Chairman Karage already expired his term. He already expired this term, meaning that the 7-year period has already expired. To continue, President Macapagal Arroyo could not have had under any circumstance validly appointed Villar as COA chairman for a full 7-year appointment, as the Constitution decrees was not legally feasible in the light of the 7-year aggregate rule. Villar had already served 4 years of his 7-year term as COA commissioner. A shorter term, however, to comply with said rule would also be invalid, as the corresponding appointment would effectively breach the clear purpose of the Constitution of giving to every appointee so appointed subsequent to the first set of commissioners a fixed term of 7 years. To, re- to recapitulate, a COA commissioner like Respondent Villar, who serves for a period less than 7 years, cannot be appointed as chairman when such position became vacant as a result of the expiration of the 7-year term of the predecessor. Such appointment to a full term is not valid and constitutional, as the appointee will be allowed to serve more than 7 years under the constitutional ban. So in this case, the the contention of Mr. Villar before he resigned that there should be a fresh period is not legally feasible, meaning that assuming that Chairman Karage did not expire the 7 years, it is safe to answer that if Chairman Villar were to be appointed in that position, he will only be allowed to hold said position until the expiration of his term in 2011. Now, ruling on the procedural issue, the Supreme Court held that the court, no, all the requisites of judicial review were not met. However, the court still continued with the case. The the Supreme Court stated that the procedural aspect comes down to the questions of whether or not the following requisites for the exercise of judicial review of an executive act obtained in this uh, petition. Number one, there must be an actual case or justiciable controversy before the court. The question before it must be ripe for adjudication. Number three, the person challenging the act must be a proper party. And number four, the issue of constitutionality must be raised at the earliest opportunity and must be the very least mota of the case. The Supreme Court stated that out of the four requisites, the third requisite is absent. That the person challenging the act must be a proper party. Supreme Court further discussed that Villar's posture on the absence of some of the mandatory requisites for the exercise by the court of its power of judicial review must fail. As a general rule, a petitioner must have necessary personality or standing, locus standi, before a court will recognize the issue presented. To have legal standing, therefore, a suitor must show that he has sustained or will sustain a direct injury as a result of a government action or have a material interest in the issue affected by the challenged official act. However, as it is clear as day that an unconstitutional appointment by Villar in no way would affect or directly hurt Funa, the petitioner. However, the court has time and again acted liberally on the locus standi requirements and has accorded certain individuals, not otherwise directly injured or with material interest affected by a government act, standing to sue provided a constitutional issue of critical significance is at stake. So in this case, even though Funa has no direct injury to the appointment of Villar as chairman of the Commission on Audit, his concern still the Supreme Court still gave leeway because his concern is that of transcendental importance. The rule on locus standi is, after all, a mere procedural technicality, the Supreme Court further stated, in relation to which the court, in a case of catena of cases involving a subject of transcendental import, has waived or relaxed, thus allowing non-traditional plaintiffs such as concerned citizens, taxpayers, voters, or legislators to sue in public interest, albeit may not have been personally injured by the operation of a law or any government act. So, to give an summary of this case, Mr. Villar's appointment as chairman is to be deemed unconstitutional because it violates the rotational system that was established by the Constitution in the terms of office of the chairperson and the two commissioners on the constitutional commissions. Next, on the procedural issue, Mr. Funa has no direct injury. As a result, there will be no direct injury for Mr. Funa if Mr. Villar would be appointed as the chairman of the Commission on Audit. However, because of the transcendental importance issue in this case, the Supreme Court decided to relax the rules on judicial review and allowed the case to continue. Further, the full text of the case actually also provides on the ruling of the mootness of the resignation of Chairperson Villar. As earlier stated in the facts, Mr. Villar had already resigned before the court could even resolve this issue, diba? He stated it in a letter dated February 2, 2011 that he had already stepped down, but the Supreme Court still continued. The Supreme Court stated that the case shall continue even though when the case is moot and academic, on four grounds. Number one, in order for a moot and academic case to proceed, any of the following must be present. First, there is a grave violation of the Constitution. Second, the exceptional character of the situation, and the paramount public interest is involved. Third, when the constitutional issue raised requires formulation of controlling principles to guide the bar, the bench, and the public. And fourth, the case is capable of repetition yet evading review. So in this case, even though Mr. Villar has already resigned from his position before it can even be ruled, the Supreme Court still continued the case because they believe that any other case like this would would ease would ease that would no longer be taxing on the court because the ruling on this case would guard the bar, the bench, and the public. Now that would be my presentation, everyone. Thank you. I'm Alan Francis Benjamin G. Calub of Group 3.
Hi everyone, I am Precious Eric Inosa, and the next case is SSS Employees Association versus Court of Appeals. The facts are as follows. On June 11, 1987, the SSS filed a complaint against the petitioners, the officers, and members of the SSS Employees Association, alleging that they staged an illegal strike and barricaded the entrances to the SSS building on June 9, 1987. The strike prevented non-striking employees from reporting for work and SSS members from transacting business with the SSS. The complaint sought a writ of preliminary injunction to stop the strike, order the strikers to return to work, and claim damages from the defendants. The SSS reported the strike to the Public Sector Labor Management Council and attempted to resolve the matter, but the strikers refused to return to work. The strike was initiated by the SSS Employees Association after the SSS failed to fulfill their demands, which included implementing the provisions of the old collective bargaining agreement on checkoff of union dues, paying accrued overtime pay, night differential pay, and holiday pay, converting temporary or contractual employees with 6 months or more of service into regular and permanent employees with the same salaries, allowances, and benefits as other regular employees of the SSS, and paying a children's allowance of 30 pesos. The Employees Association also accused the SSS of deducting certain amounts from employee salaries and committing acts of discrimination and unfair labor practices. The court issued a temporary restraining order on June 11, 1987, pending the resolution of the application for a writ of preliminary injunction. The petitioners then filed a motion to dismiss, claiming that the trial court lacked jurisdiction. The SSS opposed this motion and requested the issuance of an injunction. Later, the court denied the motion to dismiss and converted the restraining order into an injunction, considering the strike illegal. The petitioner's motion for consideration was also denied. Consequently, they filed a petition before the court. The court referred the case to the Court of Appeals in a resolution. The petitioners filed a motion for consideration, but before it could be resolved, the Court of Appeals issued its decision. The petitioners then moved to recall the decision. However, the court denied the motion for reconsideration, considering it moot and academic. The petitioner's motion to recall the Court of Appeals decision was also denied due to the court's denial of the motion for reconsideration. Therefore, the current petition is to review the decision of the Court of Appeals. The court issued a temporary restraining order upon the SSS's motion, restraining the petitioners from staging another strike or pursuing the notice of strike they had filed with the DOLE, or the Department of Labor and Employment, on January 25, 1989, and maintaining the status quo. The case has been submitted for decision after the court considered the positions of both the petitioners and the SSS. The petitioners argue that the RTC lacked jurisdiction to hear the case and issue the restraining order and preliminary injunctions, as labor disputes should be handled by the DOLE, or the National Labor Relations Commission, or the NLRC. However, the SSS argues that their employees are covered by civil service laws and regulations, not the labor code, and thus do not have the right to strike. Since neither the DOLE nor the NLRC has jurisdiction over the dispute, the RTC can prevent the employees from striking. The Court of Appeals dismissed the petition filed by the petitioner, stating that government employees, including those of the SSS, are not allowed to strike. The RTC, which had jurisdiction over the SSS's complaint for damages, could therefore enjoin the employees from continuing with the strike. The issues are as follows. First is whether or not the employees of the SSS have the right to strike, and second, whether or not the RTC has jurisdiction to hear the case initiated by the SSS and to enjoin the strikers from continuing with the strike and to order them to return to work. Fourth, according to the court, the 1987 Constitution recognizes workers' right to strike, but it is unclear if this applies to government employees. The Industrial Peace Act previously banned strikes by government employees, while the Labor Code is silent on the matter. However, the Civil Service Commission prohibits strikes through Memorandum Circular Number 6 as reinforced by Executive Order Number 180. At present, in the absence of any legislation allowing government employees to strike, recognizing their right to do so, or regulating the exercise of the right, they are prohibited from striking by express provision of Memorandum Circular Number 6 and as implied in EO Number 180. Considering that under the 1987 Constitution, and I quote, the civil service embraces all branches, subdivisions, instrumentalities, and agencies of the government, including government-owned or controlled corporations or GOCCs with original charters, and unquote. And that the SSS is one such GOCC with an original charter having been created under RA number 1161. Its employees are part of the civil service and are covered by the Civil Service Commission's memorandum prohibiting strikes. Therefore, the SSS employee strike was illegal. As to the second issue, the strike staged by the SSS employees, which belongs to the petitioner union, is prohibited by law and can be restrained through an injunction. The RTC has jurisdiction over the case because the Labor Code states that government employees' terms and conditions of employment are governed by the Civil Service Law and the rules and regulations. The NLRC does not have jurisdiction over the dispute, but rather it is the Public Sector Labor Management Council. Therefore, it was appropriate for the court to issue the injunction to prevent further disruption of public service. The court also advised the parties to refer their disputes to the Public Sector Labor Management Council for appropriate action. The next case is Republic of the Philippines versus Court of Appeals. Facts are as follows. The National Parks Development Committee, or NPDC, was originally created in 1963 under Executive Order Number 30. It was later renamed and registered with the Securities and Exchange Commission as a non-stock and non-profit corporation called the National Parks Development Committee, Incorporated. In 1987, the SEC ordered the NPDC to explain why its registration should not be suspended due to various failures, including failure to submit documents and operate continuously for at least 5 years. The NPDC chairman expressed no objection to the suspension. In 1989, the Executive Order Number 120 attached the NPDC to the Ministry, later on the Department of Tourism, and provided a separate budget. The Civil Service Commission notified NPDC that all personnel actions should be submitted through the commission. The Rizal Park Supervisory Employees Association, affiliated with Trade Union of the Philippines and Allied Services, or TUPAS, under Certificate Number 1206, entered into 2 collective bargaining agreements with NPDC in 1987. However, these unions staged a strike at the Rizal Park, Fort Santiago, Paco Park, and Pook ni Mariang Makiling at Los Baños, Laguna, alleging unfair labor practices by NPDC. As a result, NPDC filed a complaint in the RTC to declare the strike illegal and restrain it, arguing that government employees have no right to strike. On March 24, 1988, the RTC dismissed the complaint for lack of jurisdiction, stating that the case falls under the jurisdiction of the Department of Labor and Employment. The petitioner went to the Court of Appeals on certiorari on March 31, 1989. The Court of Appeals affirmed the order of the trial court, hence this petition for review. The issue is whether or not NPDC is a government agency or a private corporation, for on this issue depends the right of its employees to strike. As for the ruling, the court cited the case of Jesus P. Perlas Jr. versus People of the Philippines, where the court ruled that the NPDC is an agency of the government, not a GOCC. Hence, the Sandigan Bayan had jurisdiction over its acting director who committed estafa. As such, Its employees are subject to civil service rules and regulations as stated in Article 9 of the 1987 Constitution. Furthermore, the employees of NPDC are classified as civil service employees as outlined in Section 14 of Executive Order Number 180. While NPDC employees have the right to organize and join unions of their choice, there is currently no law that permits them to engage in strikes. In cases where there is a labor dispute between employees and the government, Section 15 of the EO number 180 specifies that the Public Sector Labor Management Council, rather than the DOLE, has the authority to address the dispute. Next case is Manila Public School Teachers Association versus Carino. Right. So after engaging in peaceful dialogues with key stakeholders, the petitioners organized mass concerted actions within the premises of the National Office of the Department of Education, Culture, and Sports, the DECS, to push for various demands. These demands included immediate payment of chalk, clothing allowances, 13th month paid, implementation of the salary standardization law, and the recall of the DECS order that resulted in oversizing and overloading of teachers. During one such action, around 800 teachers failed to conduct their classes, despite being faced with dismissal threats by the Secretary of Education, who dismissed their grievances and labeled their actions as illegal and unauthorized mass leave. The mass actions continued. The Secretary of Education then issued an order directing all participants to return to work within 24 hours or face dismissal. However, the protests persisted. Furthermore, the Secretary of Education filed motu proprio administrative complaints against the petitioners, and 20 of them were guilty of the charges. They were then dismissed from their positions, while other investigations that followed led to the dismissal of 658 teachers, suspension of 40 for 1 year, 33 for 9 months, 122 for 6 months, and exoneration of 398. Despite this, the RTC ruled in favor of the validity of the Secretary's orders. The issue here is whether or not the public school teachers have the right to strike. The court held in the negative. Unlike those in the private sector, public service employees do not have the right to strike, although they are entitled to their own self-organization and can petition Congress for improved employment terms and conditions. They can also engage in negotiations with relevant government agencies to enhance their working conditions, as long as these are not already established by law. Against this backdrop, the fact that 800 teachers participated in an unauthorized strike constituted a prima facie violation of the law. Therefore, the Secretary of Education had the statutory right to issue a return-to-work directive, press administrative charges against the petitioners, place preventively suspended those who failed to comply, and ultimately dismiss from service those who neglected to answer or dispute the accusations. The last case is Yangson versus Department of Education. Marilyn R. Yangson, holding the position of Principal 3 at Surigao Norte National High School, or Surigao National, received a memorandum on April 30, 2008. The memorandum issued by Assistant Schools Division Superintendent OIC Fidela Rosas stated that Yangson was being reassigned to Toledo Espantilo Memorial National High School, or Toledo Memorial. Yangson contested the memorandum and refused to accept it without consulting her legal counsel. Shortly before her reassignment was scheduled to take effect on May 5, 2008, Yangson filed a petition for injunction with the request for a temporary restraining order and damages. The petition was filed against Rosas and Dulcecima Corvera, who was supposed to replace Yangson as the new principal of Surigao National. Yangson argued that the memorandum violated Department of Education Circular Number 02, Series of 2005, as it did not specify the duration of her reassignment and was issued without her prior consultation. She also claimed that there was no vacancy for her position and that the reassignment would result in a demotion. The RTC issued a temporary restraining order on May 5, 2008. However, in a subsequent order on May 24, 2008, the court denied Yangson's request for a preliminary injunction. Yangson appealed the decision to the Department of Education Caraga Regional Office, but her appeal was denied by Regional Director Jesusita Arteche. She then escalated her case to the Department of Education Central Office, but her appeal was also denied in a resolution on August 13, 2008. The Civil Service Commission later overturned both resolutions of the DepEd Central Office and ruled in favor of Yang Son. The DepEd further appealed the matter to the Court of Appeals. Court of Appeals subsequently overturned the rulings of the Civil Service Commission. The Court of Appeals maintained that while reassignments are different from transfers, both are covered by Section 6 of the Magna Carta for public school teachers. However, though it was applicable, the Court of Appeals found that the provision was not violated. It explained that Yang Son was being reassigned under the division office's plan to reshuffle school administrators in the exigency of service, as the last reshuffling had happened more than 5 years earlier. The Court of Appeals also ruled that the reassignment was valid without Yang Son's consent, and the notice served to her sufficiently complied with the requirement under the Magna Carta for public school teachers. It agreed with the Civil Service Commission that Yang Son had not been demoted, as there was no reduction in Yang Son's rank, status, or salary. The Court of Appeals further found that Yang Son was reassigned to a school in the same division as Surigao Nacional. It noted that she was appointed at the Department of Education, Division of Surigao del Norte, and not any specific station or school. Citing Fernandez versus Santo Tomas, it held that since her appointment was not station-specific, Yang Son could be assigned to any school. Her security of tenure does not entitle her to permanently stay in only one school. Yang Son filed a motion for reconsideration, which the Court of Appeals denied. Thus, Yang Son filed this petition for review on certiorari. There are several issues on this case. For the court's resolution is the issue of whether or not petitioner Yang Son's reassignment was valid. In connection with this, the court resolved the following issues. You can see on the screen. First, whether or not petitioner's appointment is station-specific. Second, whether or not Section 6 of the Magna Carta for public school teachers applies. Third, whether or not petitioner's reassignment violated her security of tenure. Fourth, whether or not petitioner's reassignment was for the exigency of service. Fifth, whether or not petitioner was demoted. And finally, whether or not petitioner's appointment may be indeterminate. Holds the decision that Yang Son's appointment was not station-specific. This means that her appointment as Principal 3 of the Department of Education Division of Surigao del Norte did not specify a particular office or school. Yang Son did not dispute this fact. Therefore, her appointment was not solely for Surigao Nacional or any specific school. Her appointment paper did not indicate a particular office or station, and her position title did not specify her station either. For the second issue, it is clear that Section 6 of the Magna Carta for public school teachers does not apply in this case. This provision specifically addresses transfers, not reassignments. Yang Son's movement from Surigao National to Toledo Memorial was a reassignment, not a transfer. The legal distinction between a transfer and reassignment is significant, as a transfer involves the issuance of another appointment while a reassignment does not. Therefore, the provisions of Section 6 do not apply to Yang Son's situation. The third issue, the petitioner's reassignment did not violate her right to security of tenure. It is important to note that reassignments are different from transfers, and public employees with non-specific station appointments may be reassigned when there is an exigency of public service. The petitioner's appointment, being non-specific to a particular station, allows for such reassignments as necessary to fulfill the needs of the public service. Therefore, her reassignment to Toledo Memorial is justified by the demands of public service and does not violate her right to security of tenure. As to the fourth issue, it is evident that Yang Son's reassignment was due to the exigency of service. The Assistant Schools Division Superintendent OIC Fidela Rosas recommended the reshuffling or reassignment of secondary administrators and teachers to the Regional Director of DepEd Caraga. The Regional Director did not object, and the special meeting of secondary school administrators was held to inform teachers of the planned reshuffling of school administrators to comply with the memorandum circular. Although Yang Son was absent at the meeting, she did not deny that the meeting took place. She also cannot assert that she was insufficiently notified of her reassignment because she refused to accept the memorandum that entailed her reassignment. Furthermore, the Administrative Code allows any government department or agency embraced in the civil service prerogative to reassign employees for the exigency of service. So the fifth issue, her reassignment to Toledo Memorial does not constitute a demotion or constructive dismissal as there is no reduction in her duties, responsibilities, rank, or salary. She still retains the same position as Principal 3 and has not been assigned to a more menial or servile job. Lastly, Yang Son's argument that her reassignment should not be for an indefinite period and should not last longer than a year, assuming she was only reassigned, also fails. The maximum period for reassignment of an employee whose appointment is station-specific is 1 year. However, appointments that are not station-specific, like Yang Son's case, allow for an indefinite period of reassignment. Thank you so much.
Good evening, everyone. I am Don San Jose, and the next case is Samson Alcantara versus Comelec, GR number 203646, April 16, 2013. The petitioners here are members of the Abacada Guru Party List. The facts of the case are: petitioners filed a petition with the Comelec when the respondents proceeded to hold a Supreme Assembly that resulted to the approval and ratification of the revised Abacada CBL and the ouster and expulsion of petitioners from their positions into the party. The petitioners allege that the sending of notices and the holding of a Supreme Assembly were contrary to the party's CBL for not having been authorized by the President and by the party's National Executive Board. They allege that Albano, the acting secretary, has no authority to sign and send notices, much less call a Supreme Assembly since he is not the party's secretary. Also, the membership status of several meeting participants have neither been approved nor accepted in accordance with the party's CBL. The COMELEC dismissed the petition and ruled that the respondents had good cause to initiate the holding of the meeting. The petitioners moved for reconsideration of the ruling, questioning the division's failure to address the issue of validity of the Supreme Assembly based on the non-membership status of several meeting participants. The COMELEC and Bank denied the motion, hence the appeal. So the issue in this case is whether or not the Supreme Assembly is void for it not convened in accordance with the party's CBL. The court ruled that the Supreme Assembly is valid. Abacada's Constitution expressly requires the convening of a Supreme Assembly once every 2 years for the purposes of electing the members of the National Executive Board, which is the governing body of Abacada. The court dismissed the petitioner's argument that those who attended the Supreme Assembly are not really members. Therefore, their acts are not valid because petitioners fail to establish who the members are at the time of the Supreme Assembly. The petitioners opened their petition with the principle that only members of a registered party can chart its destiny to the necessary exclusion of non-members. The COMELEC correctly observes that while this may be true, all the petitioners establish is the group's membership as of 2003. The petitioners fail to account for the group's actual membership of at least as of 2009, 5 years after Abacada was accredited, and the year immediately prior to the Supreme Assembly held in February 2010 and the party-list elections of May 2010. As the party, seeking to nullify the conduct of the Supreme Assembly, the petitioners must first clearly substantiate their allegations on who the legitimate members of Abacada were at the time the Supreme Assembly was held. What the petitioners presented are merely applications for memberships with Abacada as of November 3, 2003, during the party's inceptive stage. Hence, the court dismissed the petition and allowed Abacada as a sectoral party to determine its own affairs under its present leadership. The next case is Carubin versus Comelec, GR number 218787, December 8, 2015. The facts of the case are, on October 27, 2014, the Comelec, through resolution number 14-0715, released the bidding documents for the two-stage competitive bidding for the lease of election management system and the precinct-based optical mark reader or optical scan system that will be used in the 2016 national and local elections. The joint venture of Smartmatic International Holding, Jartec International Corporation, and Indra Sistemas responded to the call and submitted bid for the project on the scheduled date. Smartmatic JV and Indra then participated in the end-to-end testing of their initial technical proposals for the procurement project before the COMELEC Bids and Awards Committee. The COMELEC BAC, through its resolution number 1, declared Smartmatic JV and Indra eligible to participate in the second stage of the bidding process. The BAP then issued a notice requiring them to submit their final revised technical tenders and price proposals, to which the eligible participants complied. Finding that the joint venture satisfied the requirements in the published invitation to bid, Smartmatic JV on March 26, 2015 was declared to have tendered a complete and responsive overall summary of the financial proposal. Meanwhile, Indra was disqualified for submitting a non-responsive bid. For purposes of post-qualification evaluation, the COMELEC BAC required Smartmatic JV to submit additional documents and a prototype sample of its optical mark reader. After the conduct of post-qualification, the BAC disqualified Smartmatic JV on two grounds. First is the failure to submit a valid article of incorporation. Second is that the demo unit failed to meet the technical requirement that the system shall be capable of writing all data, files, audit log, statistics, and ballot images simultaneously in at least 2 data storages. The ruling prompted Smartmatic JV to move for reconsideration, but the motion was denied due to the non-compliance with the technical requirements of the project. Aggrieved, Smartmatic JV filed a protest to the COMELEC seeking permission to conduct another technical demonstration. The COMELEC NBank ruled that the instant protest is granted and to return to prospective bidders their respective payments made for the purchase of bidding documents pertaining to the second round of bidding. The petitioner now assails the decision of the COMELEC. The issue in this case is whether or not the petition is the proper remedial vehicle to assail the subject decision of the COMELEC NBank. The ruling of the court is that the petition lacks merit. Rule 64 is not applicable in assailing the COMELEC NBank decision granting Smartmatic JV's protest. The instant petition revolves around the issue on whether or not Smartmatic JV is eligible to participate in the bidding process for the COMELEC's procurement of 23,000 units of optical mark readers. The case does not stem from an election controversy involving the election, qualification, or the returns of an elective office. Rather, it pertains to the propriety of the polling commission's conduct of the procurement process and its initial finding that Smartmatic JV is eligible to participate herein. Rule 64 applies only to judgments or final orders of the COMELEC in the exercise of its quasi-judicial functions. The rule does not apply to interlocutory orders of the COMELEC in the exercise of its quasi-judicial functions or its administrative orders. The subject matter of Smartmatic JV's protest does not qualify as one necessitating the COMELEC's exercise of its adjudicatory or quasi-judicial powers that could properly be the subject of a Rule 64 petition that is in fact administrative in nature. The next case is Francisco versus House of Representatives, GR number 160261, November 10, 2003. So this case falls under the topic of accountability of public officers. In this case, within a period of 1 year, two impeachment proceedings were filed against Supreme Court Justice Hilario Davide. The controversy in this case was the constitutionality of the subsequent filing of a second complaint to controvert the rules of impeachment provided for by law. The facts of the case are, on June 2, 2003, former President Joseph Ejercito Estrada filed an impeachment complaint against Chief Justice Hilario Davide Jr. and 7 associate justices for culpable violations of the Constitution, betrayal of public trust, and other high crimes. On October 2, 2003, the House Committee on Justice dismissed the complaint for insufficiency of substance. Pursuant to the Constitution, the House of Representatives, in plenary session, has still to approve or disapprove the committee's action. On October 23, 2003, Congressmen Gilberto Teodoro and Felix William Fuentebella filed another impeachment complaint, this time against Chief Justice Davide alone, charging him with violations of Anti-Graft and Corrupt Practices Act and betrayal of public trust with regard to the disposition of the Judicial Development Fund. At least 1/3 of all members of the House signed a resolution endorsing this second impeachment complaint. Subsequently, the instant petitions were filed with the court alleging that the filing of the second impeachment complaint against Chief Justice Davide violates Section 3, Paragraph 5, Article 11 of the Constitution, which provides that no impeachment proceedings shall be initiated against the same official more than once within a period of 1 year. The issue in this case is whether or not the filing of the second impeachment is unconstitutional. The ruling of the court is that the second impeachment complaint against Chief Justice Davide is barred under Paragraph 5, Section 3 of Article 11 of the Constitution. The provisions of Section 16 and 17 of Rule 5 of the House Impeachment Rules contravenes with Section 3, Paragraph 5 of Article 11 as they give the term initiate a meaning different from filing. Under the above rules, when the verified impeachment complaint is filed by a member of the House or by a citizen through a resolution of endorsement by a member of the House, impeachment proceedings are deemed initiated either first on the day the Committee on Justice finds that the verified complaint and/or resolution is sufficient in substance, or on the date of the House, through a vote of 1/3, overturns or affirms the finding of the Committee on Justice that the verified complaint and/or resolution is not sufficient in substance. However, when the verified impeachment complaint or resolution is filed or endorsed by at least 1/3 of all members of the House, impeachment proceedings are deemed initiated at the time of the filing of the verified complaint or resolution with the Secretary General. The deliberations of the Constitutional Commission clearly revealed that the framers intended initiation to start with the filing of the complaint. The vote of 1/3 of the House in a resolution of impeachment does not initiate the impeachment proceedings, which was already initiated by the filing of a verified complaint. Thus, under the 1-year ban on initiating impeachment proceedings, no second verified complaint may be accepted or referred to the Committee on Justice for action within 1 year from the filing of the first verified impeachment complaint. The last case is Gutierrez versus House of Representatives, Committee on Justice, GR number 193459, February 15, 2011. The facts of the case are, 2 impeachment complaints were filed against Ombudsman Gutierrez. Both were based on betrayal of public trust and culpable violation of the Constitution. The first impeachment complaint against Maria Merceditas Gutierrez was filed by Risa Hontiveros. The second complaint was filed by Reyes against the same respondent, but also based on the betrayal of public trust and culpable violation of the Constitution. The two complaints were referred by the House plenary to the Committee on Justice at the same time. The House of Representatives provisionally adopted the rules of procedure in impeachment proceedings of the 14th Congress. After hearing, House of Representatives Committee on Justice found two complaints which both alleged culpable violation of Constitution and betrayal of public trust, sufficient in substance. Consequently, Ombudsman Gutierrez contended that the issued resolution violated the one-year ban provision under Article 11, Section 3, Paragraph 5 of the Constitution. The issue in this case is whether or not the House of Representatives Committee on Justice violated the one-year ban provision when it issued the resolution. The ruling in this case is that no, Article 11, Section 3, Paragraph 5 of the Constitution provides that no impeachment proceeding shall be initiated against the same official more than once within a period of 1 year. The act of initiating the complaint means the filing of the impeachment complaint and the referral by the House plenary to the Committee on Justice. Petitioner Ombudsman Gutierrez contends that it is reckoned from the filing of the first impeachment complaint against her on July 22, 2010, or 4 days before the opening of July 26, 2010 of the 15th Congress. He posits that within 1 year from July 22, 2010, no second impeachment complaint may be accepted or referred to public respondent. As held in the Francisco case, once an impeachment complaint has been initiated, another impeachment complaint may not be filed against the same official within a 1-year period. Therefore, the 1-year period ban is reckoned not from the filing of the first complaint, but on the date it is referred to the House of Committee on Justice. Hence, in this case, the committee did not violate the 1-year provision of the Constitution when it accepted the second impeachment complaint after the first impeachment complaint was filed. Thank you very much, attorney and classmates, for listening to our report.